1968ခုနှစ်မြန်မာနိုင်ငံတရားစီရင်ထုံးစာမျက်နှာနံပါတ်450ဦးပွ applicant vs ဦးမြင့်မောင် respondent ဤစီရင်ထုံး audio book ကိုအထက်တန်းရှေ့နေဦးအောင်ခိုင်ဦးအထက်တန်းရှေ့နေဒေါ်ပြည့်ပြည့်ဖြိုးနှင့်တရားလွှတ်တော်ရှေ့နေဦးထိန်လင်းဦးတို့မိသားစုကစီစဉ်ဆောင်ရွက်ပြီးဒေါ်ယူပါစော်မင်းမှဖတ်ကြားခြင်းဖြစ်ပါသည် Criminal Revision Before ဦးကျော်ဆန်းဦး Judge ဦးပွ Applicant vs ဦးမြင့်မောင် Respondent Civil Procedure Code Section 517 1. Return of property to the person claiming to be entitled to possession thereof. Held under Section 517(1) of the Civil Procedure Code, the property is to be returned to the person claiming to be entitled to possession thereof. There is no dispute that the exhibit tobacco stock was seized from the possession of the applicant, who was acquitted in the case. The trial court held that the respondent could not prove entrustment, so, for the purpose of Section 517(1) of the Code, it was the applicant who was then in possession of the exhibit. The goods being movable properties, the presumption of ownership is in favor of the applicant who was in possession and against whom the respondent could not prove entrustment in the criminal case where the applicant was acquitted. Hogan vs. Unwanted 1949 BLR 647 HC referred to U Maung for the applicant, Mr. Vincent Po for the respondent. U Jiao San U, Judge in Criminal Regular Trial numbered 197 of 1965 of the Court of the Township Magistrate of Nyanglebin, Ko Myin Maung, Echo Smith, prosecuted Ko Pua under Section 406 of the Penal Code, stating that with K4,000 borrowed from Ko Pua, he bought tobacco stock which he entrusts with Ko Pua, with the intention of selling with a profit in order to repay the loan to Ko Pua, who instead converted the tobacco stock as his own by granting them. The trial court held Ko Myin Maung failed to prove entrustment satisfactorily and acquitted Ko Pua, returning at the same time to him 193 bags of exhibit tobacco stock, which he had ground out of 295 bags, and the balance 102 bags were returned to Ko Myin Maung, the complainant. Being dissatisfied, Myin Maung applied to the Additional Session Judge of Bago in his Criminal Revision number 2 of 1967 to revise the order regarding the disposal of the exhibit, stating that though 193 bags of tobacco stock had been ground by U Pua, they belonged to him. In Criminal Revision number 4 of 1967 of the same court, U Pua also applied to revise the same order, stating that since he has been acquitted on the ground that Ko Myin Maung could not prove entrustment, the return of 102 bags of tobacco stock to him is against the law. He further stated that since he was in possession, they belonged to him. these two revisions were had together and a single order was passed on 11 February 1967, covering both. The additional session judge was of the opinion that, though MAUNG could not prove his title to the goods, the evidence showed that these goods did arrive at Upwa Mill. In other words, Upwa was in possession and he would be responsible for any loss. The additional session judge was also of the view that the exhibit were treated as one unit and, since the charge was framed accordingly, the trial court ought not to have split them into two, such as ground and unground tobacco stock. He said in his order the parties through their lawyers also held the same view. Finally, he held that the entire exhibit should be returned to MAUNG, who had openly bought them, and rejected Upwa application. I think the additional session judge decided on the wrong principle. Being dissatisfied with the order passed in both the cases, Upwa came out to this court and filed these two separate applications to revise the order. This order shall therefore cover both the cases. Under Section 517(1) of the Criminal Procedure Code, the property is to be returned to the person claiming to be entitled to possession thereof. There is no dispute that the exhibit tobacco stock were seized from the possession of Upwa, who was acquitted in the case. The trial court held that MAUNG could not prove entrustment, so for the purpose of Section 517(1) of the Code, it was Upwa who was then in possession of the exhibit. The goods being movable properties, the presumption of ownership is in favor of Upwa, who was in possession and against whom MAUNG could not prove entrustment in the criminal case, where Upwa was acquitted. In Houquan v. Unwanted 1, it was pointed out that the guiding principle is that though the magistrate has a discretion to decide the question of possession, he cannot be allowed to try the civil cause as to ownership. The established rule is to return the exhibit to where they came from. Ordinarily, they must be returned to the party from whom they were seized. But if the party from whom they were seized has no apparent right or title, they should not be returned to him. In the instant case, MAUNG has yet to prove his right or title to the exhibit. In the result, the order of the additional session judge of Bago is set aside in both the cases, and it is directed that the entire exhibit be returned to Upwa.